All right. Sup, perps? What is going on? I know it's been forever since I've been live. It is what it is. Just been busy. Work midnights now, so can't watch. Yeah, dude, I feel that. We've just been busy, man. Quite a bit of stuff going on. Um, just trying to stay on top of stuff, man. But I figured I haven't streamed in a while, and I need something to keep me busy before I go pick my kiddos up later on. So I figured we'd do this. Jason, what is up, my brother? How you and the wife doing? Dang old Matt's checking in. Brother Matt, what is up? Here for some oral? Yeah, we're going to do it. We're also going to look at, because I was in a big meeting Monday when the oral arguments were held for this. And I wanted to look at some of the testimony or supporting documents that the state's using to support their bullshit case. And we're going to look at some of that. I think we're going to listen to the oral arguments first, and we're going to look at some of the stuff. And I've got links posted in the description. Shayna, what's up, sis? But I've got links posted in the description for court listener, where basically all these documents are at. And like I said, we're going to look through some of them. But I want to listen to our arguments first, just to kind of get back into the mindset of looking at the case as a whole, or what the judges were hearing. Miss Gina, what's going on, sis? Long time no see. Too many choices, brother, man. What's going on? I catch everybody's shorts and videos and stuff like that, but man, yeah, you guys know I haven't done a whole lot of anything as far as streams in the last while. So life gets busy and it comes at you fast. Now I think, let me see, I've got this up over here. And I'm going to use court listener instead of going to YouTube for the arguments. I think I'm going to use court listener because their stuff may not drag me down as much. And it has been so long since I've used StreamYard, and they've changed up some stuff that I got to figure this crap out again. Because it is serious, man. It's been so long since I've done anything, and they have changed up some shit. So let me see. You guys bear with me, man. I look like well, I am an absolute retard, but that's beside the point. Here we go. I believe this is it. And let me make sure I did that right, because I want to make sure the audio comes through like it should. Just give me just a sec. Yeah, it's what can I say? It's me. All right, it says to share audio, so we're good there. Da da da. All right. And this is kind of, which, I mean, my connection drags sometimes anyway, but this seems like it's dragging a little more than normal. So you guys give me a 5x5. I'm fixing to hit play on this, but let me know, make sure everybody can hear it, because this was the oral arguments held. Hold on. No, this isn't the one I was looking for. No. Hold on. I may keep that one up. And we'll go to the YouTube side instead, because I know these are the right arguments here. Because this was Monday, so. It'll start in just a sec. I don't want to bump it too. Here we go.
Good afternoon, ladies and gentlemen. We are about to hear argument in the case of Barnett against Raoul. Ms. Murphy.
Is that a squeaky toy in the background?
Solicitor General Sarah Hunger on behalf
It's killing me already.
of 249, which provides suppression fire. And so typically individuals that have the M6 fire, and it's only in kind of unexpected or rare circumstances that they would use that for automatic fire.
Your membership is more than just a card. It's your gateway to extraordinary.
Sorry about the ad. Let's see whether this will smooth out real quick. All right, let's see if we can get back at this. Trying to change a couple things, and maybe I can smooth this crap out. It would figure the minute I get back on the stream, my connection's worse than it normally is. Gee, thanks.
Or because it's disputed but not dispositive, or because it was clearly erroneous. But that being said, De novo review.
But your de novo review wouldn't apply to the district court's findings of fact, which I know you have argued the district court didn't make them. And I think maybe you should move on to the fact that there were some made, not in your traditional, here's your findings of fact and conclusions of law, but the law doesn't require a particular format. So the district court did make specific findings differentiating AR-15s from M16s and M4s. And how do you get around that?
Sure. So just quickly, Your Honor, this court has said in Schoenthal and in Rush that the standard of review is de novo for Second Amendment claims. I understand that in Schoenthal, it was a summary judgment posture, but the court did say it is both because it's summary judgment and because it's a question of law. And in other
But de novo review can apply to the legal question, but there are particular facts here which we sent the district court back to explore and develop. And those factual findings, the clearly erroneous still applies to.
Well, this court remanded to develop. It did not remand for factual findings and did not instruct the court to have a trial. Our view is that this could have been resolved on summary judgment. As Your Honor has pointed out, that's how most courts have addressed this across the country.
Those are preliminary injunction cases, though. This is a merits case, and it's gone down once, it's come back. I'm wondering if we'd hear the same argument from the state if the M16s and AR-15s are the same. I think you'd be relying upon the clear error, don't you?
No, I mean, before the district court, we have been consistent that we believe these are legislative facts. They are questions of law, and the plaintiffs agreed before the district court. If you look at document 2 facts and not adjudicative facts,
You didn't raise that argument here until your reply brief. Have you waived that legislative facts argument?
No, we have not waived
Why
that. We
not?
did say that.
Yeah. Thank you.
We did say that de novo review applies because it's a question of law, and also that, I suppose the district court did not make any findings of fact. I would view this as a sub-argument of that.
But the test, back to your no findings of fact, the test that this court developed in Beavis at step 1 required factual determinations. So the ultimate question and ultimate analysis is a legal one, but step 1 under our Beavis test, which is at the moment still the law of this circuit, required factual determination. So yeah, I know you're
I can move on
resisting
to,
that.
Yeah.
But I don't know
Yeah,
how you
I
can
can-
resist
right.
that given the test that was set forth.
I'll say, I'll respond to that, and then I can move on to kind of the findings that were made by the district court and address those in turn. In Beavis, the court remanded and said, if there is additional factual development, it could change the outcome. It did not, unlike in other decisions that I've seen, say we are remanding for these specific findings of fact to be made so that we can answer this outstanding question. It simply invited the parties to develop the evidence, and if it did so, could change the outcome here.
Isn't there a related question under Federal Rules of Procedure 52B? The state could have made a motion to amend the findings of fact up to 28 days after the judgment, and I don't think that motion was made. So if the state did have trouble with those, why wasn't that type of a motion filed?
Well, again, because our view, consistent with the way that the district court set up its decision, which is legal analysis, is that this is a question of law. So I think our position is actually consistent from the district court until now. But again, I'm happy to address any of the statements that were made by the district court, because I do think to the extent the clearly erroneous standard or some other deferential standard applies, because I do think adjudicative versus legislative facts, where it says that the clearly erroneous standard might, but
There is case law on that, but I'm sorry, I think I may have cut you off and prevented you from answering the why question. Why haven't you waived or forfeited that legislative fact argument by not
Give me a second, guys. For some reason, it just disconnected the freaking screen share. All right, I think we're back. Freaking part of this is probably my computer, and part of this seems like StreamYard right now acting retarded.
Made, I think one that we could start with is whether or not these weapons are useful for self-defense purposes. I think that was the reason why these are useful for self-defense is because, quote, more rounds equals a higher chance of survival. And that is something you see in the plaintiff's brief here and also in their expert reports. Watt and Little both kind of make this statement. It's their view that more rounds equals a higher actual Lucy analysis.
We're going to look, if we get time, and hopefully we get time, we're going to look at this Lucy Allen report because I downloaded it from Court Listener earlier. So we're going to see Miss Allen's report, and the judges should have seen it and read it. And I'll guarantee it's absolute horseshit. So we're going to look at it.
Database and also news sources, as well as a couple of other databases, and found that in assessing the empirical evidence, on average, shots, and that's 0.3 unsupported statement by an expert saying more rounds is better for self-defense, when there is an empirical assessment in the record showing that only 2.2 rounds are necessary. So that is an example, I think, of if we are required to meet the clearly erroneous standard, we would meet it. I also think there's evidence.
Just reweighing evidence?
No, it's not reweighing evidence.
You have an expert giving expert opinions, and
I heard this. I understand there's this evidence in the record, 2.2 shots. However, I was persuaded, by this specific statement. The district court did not do that. And so we
Hard argument to make though, because opinion's over 160 pages long. I mean, it's very detailed. It itself builds upon this very large trial record, which itself builds upon hundreds of pages of findings of fact submitted by both parties. So isn't that a tough argument to make that the district court didn't cover something in such a lengthy opinion?
Well, I'm happy, to respond to another statement where the district court did support that in the way that I just described. I've read the opinion several times, and there's a lot of, I think the first 100 pages are a discussion of the case law. It's really pages 100 to about 120 that have the analysis there. And there are statements made like that, again, I'm happy to point to, the district court's, the record in front of the district court, because even under a clearly erroneous standard, there is still a review of the evidence, and this court can find that a determination was clearly erroneous. Again, we don't believe that is necessary. Other statements that are made by the district court, additionally, because of the features that individuals could rely upon in self-defense scenarios. But all of those features, if you look at even the plaintiff's expert report, rely upon the assumption that there will be rapid, sustained fire. And that is just not the case at what actually happens in self-defense scenarios. For example, Watt says The pistol grip aids in, quote, rapid follow-up shots. The flash suppressor helps fire follow-up shots at faster rates. The forward grip helps in adverse weather conditions. These are not things that happen in self-defense scenarios. If you're looking at self-defense in the home, which is where somebody in Illinois would use an assault weapon because we have a concealed carry ban that only allows handguns and not other weapons out in kind of the public. If you're looking at a home self-defense scenario, it's close encounters, again, 2 to 3 shots. You're not looking for long range. These features are not necessary, and also they're not chosen by individuals.
Does it have to
for
be home?
self-defense.
Do you have to look at this from a home self-defense perspective as opposed to a broader self-defense perspective?
No, but I do think that in Illinois, it would be in the home, if that makes sense, practically speaking, just because of how all of the different firearm laws work together. So Illinois does have a concealed carry regime where you can carry handguns or guns that you can conceal. And so I think just realistically, it would be a home.
And that is why I wanted to use court listener, but couldn't find the exact audio I wanted. Why the 7th Circuit has commercials played on this shit, I have no idea.
You might be able to carry these weapons out in public. But, I think the context here does matter when you're looking at the type of self-defense scenario that individuals attempting to use this firearm in Illinois would use. I also think it's important that the evidence in the record shows that in the moment of needing to use a firearm for self-defense, individuals choose handguns. They do not choose rifles. Again, I'm going back to the Lucy Allen report, but it is very helpful. And she looked at the Heritage Foundation's defensive gun use database. And based on the reported data there, in 90% of self-defense situations, individuals reached for a handgun, 6% reached for a shotgun, only 4% reached for a rifle. And so we have empirical evidence in the record showing that these weapons are not necessary for self-defense. They're not chosen by individuals for self-defense. They're not even the most useful.
Report focused on Illinois, or is it broader?
It's broader.
And would your statement that you said earlier about not here, would that impact the Lucy Allen report at all? So could her statistics be off if her focus was not based on Illinois and the concealed carry, et cetera?
No, I don't think so. I mean, in this kind of universe, to be perfectly honest, is we have just different types of data available, type of data that she could get, and that's what she could find. In other states, there are state-specific databases. I'm not aware of any in Illinois, so I don't remember.
When we're pointed to evidence like this, though, I'm struggling to see how this is not reweighing. I mean, we're looking at the district court's findings, and the district court is reaching these conclusions after reviewing the record and hearing all the witnesses. Isn't that what we should be pointed to versus individual items in the record?
No, Your Honor. And I also think, though, there's a question about when, to the extent there is a different standard of review for facts and for law, there's also a question of, well, what's a factual finding and what's a legal determination? My view would be, even if this court were to afford deference to the findings of fact, something like, is this suitable for individual self-defense is a legal question. Is this weapon militaristic? Would be a question of law. I mean, I think some of those are legal questions, even if there are at the base level some factual determinations. But I also think, there's a lot in the record that is not disputed. If you look at the militaristic side of things, all of the specifications and the features and the capabilities are not disputed as I understand it. For example, we all agree that the semi-automatic, feature of the M16 and the AR-15 are the same gun. We also agree that the select fire capability does allow for automatic fire, and there is a difference, for example, in the rate of fire. And if you look at the numbers that are in the record, the difference now is 135 rounds per minute between the M16 and the AR-15 if you're looking at automatic versus semi-automatic mode. Before this court in Bevis, using the theoretical rate of fire.
Did the district court make findings on that question?
The district court just said that there was a difference in the rate of fire, and we agree with that.
Yeah, but did the district court you just used a particular number of rounds per minute, findings about the effect of the size of the magazine on the rate of fire?
No.
Even though we had identified both issues, as issues that needed development in the district court.
Correct.
Okay.
in the record on the individual self-defense that they had self-defense experts. We had experts that testified. We did not characterize them as such, but we did have individuals like Yergolitis and Andrew that I believe could be characterized in that way. I mean, their self-defense experts are individuals who have businesses that
No, this is getting just absolutely retarded. I'm sitting here watching my connection go up and down like a freaking yo-yo for no reason. We're going to try this again because apparently I just really like the pain. Yeah, man, I might have to figure out something and reboot all my stuff because it's been a while. We'll see.
credit that testimony or not, or that it would be clearly erroneous to credit that testimony.
The freaking minute I go to do something, this thing just drops off to nothing.
And we had our historian look, Professor Delay, and he put in additional.
It prohibited not just the carrying, but the possession and acquisition of an entire class of arms.
There was, let me see here.
Do you want to know where to invest $1,000 right now? Well, forget about AI, quantum
No, I don't want to
computing,
know.
electric vehicles.
At the founding. I do know that most of them come later. Most of the possession statutes come in the 19th and 20th centuries, but as this court has held, that time period is
Why?
so it was a ban on possession of trap guns in 1771 in New Jersey. That was the example that I was thinking of. And then, let's see here, there were 8 more of those bans in the 1800s and 9 in the early 19th century, then semi-automatic, and
That's where there's a
reaching a different result than the one that this court reached in Bevis. And because the historical tradition is about reserving, dangerous weapons for law enforcement and military use, and restricting civilian access to these especially dangerous weapons in a manner that is appropriate for the danger that they pose. And so these in the possession, because you don't want a trap gun at your house, you don't want it out in public, but these knives, these clubs, these other types of smaller weapons, the danger was that somebody would have them hidden under their coat, and and so they didn't ban the possession, they banned the carriage of it. And that's consistent with the Second Amendment. The idea is that states and localities should not be banning things in a scope that is broader than necessary. And so our view is that this is consistent with all of these statutes. And again, the plaintiffs, all of this, was in front of this court in Bevis. And the court decided that the state had satisfied its burden.
You're arguing as if there wasn't a remand. There was a remand for us to answer some of these, have some of these questions answered, then come to us for us to perform our appellate function. And that's the record has changed as a result of that. That's what we're dealing with.
But only in our favor is what I am saying, that the plaintiffs did not put in any additional evidence. And in fact, the plaintiffs just reiterate this view that if there are enough of these in circulation, then it's in common use, and therefore it accords with the historical tradition. And on that point, they actually have less evidence than when they came here before. Because it
seemed like in the district court at step 2, at step 1, there was a lot of additional evidence put in about whether or not these weapons are arms. And the district court made specific findings that these are arms and supported that with particular findings. I know you disagree with that, but there, in the opinion, there are enough findings in there, different from what the Bevis 1 preliminary injunction record looked like. But it did not
in the context of these dangerous and unusual restrictions. But, to be quite honest, our experts did a very thorough job at the preliminary injunction stage. And when we asked them, we asked them to go back, said, you have more time now. Could you please look for more? And they did find a little bit more, but they said, this is the historical tradition. It's consistent with what we put forward before. And I will note the plaintiffs below tradition. They had the opportunity to do that. They did not even hire a historian. They did not do that. Instead, they just came back to this view, which was already rejected by this court and has been rejected by multiple circuits around the country, that if a weapon is popular, it is consistent with the historical tradition. And as I noted before, they actually have even less evidence on that because many of the surveys that they relied upon at the preliminary injunction stage turned out to be methodologically or ethically flawed, and the district court struck those from the record. And they have not tried to revive those on appeal. 2,000 of these registered in Illinois. And so our view is that there's actually less in the record supporting the plaintiffs at which we do not believe is appropriate, we would still prevail. We believe we have still satisfied our burden at the second step.
Since you first Beavis was shortly on the heels of Bruin, and we were one of the first courts to tackle the challenges of Bruin. There has been additional case law that has come out, including Rahimi.
Yes.
What is the state's position as you're here today on how we should construe dangerous and unusual? Is it dangerous and unusual, dangerous or unusual, unusually dangerous? The courts that have addressed it are a little bit all over the place.
You know, a little bit, but I was actually reviewing the decisions for that issue a couple of days ago. And in addition to Beavis, the Lamont, the Bianchi, and the Hansen decisions have kind of centered around this particularly dangerous, especially dangerous terminology that was used by this court. So
This is getting Warsaw. What's up, brother? Me and my country ass internet are fighting today. The first time I've streamed in forever, and this is gonna pull this shit. It's about to drive me nuts. First time I've streamed in forever, and this is gonna pull this shit. It's about to drive me nuts.
as a separate test, because if so, then you get into this situation which this court in Beavis, where you're saying, well, what is unusual? Does it really mean that if enough of these are in circulation, we can't ban that? And, is, the court pointed out in Bianchi, it also runs counter to Heller and Bruin, because the court is looking at use and not possession. It also is important because in Heller, the court said that are in common use. It didn't, that was pointed out by.
Does that make any sense to be protected at all? One of the Supreme Court's decisions involves nunchakus, which I don't think are in common use.
Well, no, it said that. Well, that is what Bianchi said. I suppose it did say that.
Yeah, but
In
it's not
Heller,
Supreme Court
it was talking about kind of an interpretation of that statement of Heller, that it should not be read to say that if it's in common use, it's automatically protected, because it made the opposite statement, whether or not that makes sense in Heller.
That goes more to the common use element rather than the danger.
Hold on, guys. More technical difficulty. I think we're back.
Nuanced approach circumstance.
No, our view is that we would prevail under either. I do think, though, this is
What's
all.
I'm gonna fucking scream doo-da.
With that.
Goals underlying it, or the more nuanced approach. I mean, we have not gotten more clarity, of course, from the Supreme Court, but I do think that the more
Sorry. Flipping through a couple things, trying to figure out what the hell's dragging this connection so far, and I can't find anything that should be dragging it.
For any type of refinement or additional standard.
That's supposed.
As if I needed any more reasons to hate the Seventh Circuit this much more. Or my connection.
That would exist in this case.
Well, I disagree with that. I think that although there were certainly mass murders, and this is, and if you look at the act that is at issue here, it is designed to address mass shootings, and that is a new societal concern. It is not attempting to address homicides or mass murders more generally, and it does not say that it is attempting to do that, because it's not regulating other types of actions that could lead to mass murders. It's not regulating, bombs or other types of of weapons, right? It is regulating the weapons that are used in mass shootings, and that is a change. And also the technology has changed.
I'm sorry, I'm losing you where the change happens, because there have been mass shootings as that's defined going back, 100 years more. It's not, if it's a technological change, I'm not sure.
All right, we're going to try this for 9,958th time. Hold on, let me freaking get this right. It's about to drive me completely up the wall. Let me see something. Let me do. I'm going to play with a couple more settings here and see whether I can't get this thing to actually try to run half-ass smooth, which I know it probably won't because it's my luck.
Not regulating, bombs or other types of,
Try it again.
of weapons, right? It is regulating. And that is a change. And also the technology has changed.
I'm sorry, I'm losing you where the change happens, because there have been mass shootings as that's defined going back 100 years more. It's not, if it's a technological change, I'm not sure how, for example, the AR-15 would differ from a weapon 30 years ago. If it's a mass shooting circumstance, I'm not sure. We can't be myopic in our history with regard to when these.
Well, it's much more frequent that it is happening recently. And we don't just things that are happening now. And, as Justice Barrett indicates, the ability to regulate simply because they did not do it at the earliest possible moment. And that, I think, is an important concept here. Simply because there was, say, a mass shooting in the 70s or in the 80s, and Illinois did not regulate at that moment, it doesn't lose its constitutional capability to do so. And that's why you see different states doing this at different points in time, and that is fine. And, if it were anything else, then you would have states feeling the need that they needed to regulate right away, before seeing if these weapons were dangerous, before seeing if they proliferated and caused a problem. And so I think it's actually beneficial for both sides here, for the state to respond to an actual societal problem when it arises, and not to have this a use it or lose it approach.
The concern is that the level of generality gets so high.
Acorns lets me focus on today's goals while they handle
Another
tomorrow's.
freaking ad.
Being the financial wellness app built
That the analogical reasoning breaks down.
But I don't think that the level of generality is so high. I mean, mass shootings are a very specific type of event, and this law was enacted to prevent that type of shooting. Just like, you know, the automatic weapons around prohibition, horrible shootings, and there was legislation enacted to, you know, restrict automatic weapons. And I just don't see how, if that is constitutional, which the Supreme Court has said it is, the state's response now could be unconstitutional. And those seem very similar to me. The Supreme Court has said that restrictions on assault weapons or restrictions on automatic weapons today. And so I think at the second step, the how and the why is very close. This court did look at all of those analogs in Beavis, and there's no reason for this court to depart from that reasoning here. I believe I might be going into my reserve time.
One
but I'm
more
happy,
question,
yeah.
Ms. Hooker, please. So the opinion here in the briefs really focus on AR-15s and large capacity magazines. And as you know, the act at issue covers a lot more than that. What are we to do with the a lot more?
Right. So other courts have looked at this as well. And if you look at, I think it's Capon and Bianchi, essentially what the court said is that if the state prevails on AR-15s, it's likely, you know, it's going to prevail on the rest of the items, especially because the plaintiff's whole case is that because these are so popular and they are in common use, they are lawful. That cannot plausibly be said about the shotguns and the pistols and the bump stocks at issue in this case, the grenade launchers.
But can
and
we
so
make all those determinations on this record? I guess that's what my
right.
concern is, that the focus really was on AR-15s
Right.
and large capacity magazines.
Our view is that the state has put in sufficient evidence. If you look at the Yergolaitis declaration, between pages 55 to 72 are devoted to shotguns and pistols and some of the other weapons at issue here. So we believe that we have carried that burden. If this court finds that there is simply not enough in the record, it could decide the case as to AR-15s and similar rifles, make it a rifle case. And then the plaintiffs, I suppose, could come back in a different case with more of a focus on the shotguns and the pistols. If your honors have no further questions, I will reserve the rest of my time. Thank you.
Certainly, Ms. Hunger. And now, Ms. Murphy, it's actually you.
Thank you, Your Honors, and may it please the court. Erin Murphy on behalf of the plaintiffs, and I think you know I'll be taking 35 minutes on behalf of all the plaintiffs, followed by Mr. Mag and Ms. Dillon for the government. When this case was last here, the court held that the plaintiffs, quote, have the burden of showing that the weapons addressed in the pertinent legislation are arms that ordinary people would keep at home for purposes of self-defense, not weapons that are exclusively or predominantly useful in military service, or weapons not possessed for lawful purposes. And it remanded for the parties to develop a better record on issues like the comparative firing rates, ammunition, kinetic energy, muzzle velocity, etc. We took those directions to heart.
I really worry about the blah, 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 et cetera, given that the district court didn't make findings on several of the things we told it needed to.
Well, I think the district court made more findings than you're giving the court credit for. And we put on evidence on pretty much every metric that I think this court identified in its opinion. And we put on evidence about firing rate, about kinetic energy,
Did the district court make findings about those things?
I think the district court did. So rate came up earlier, firing rate. I'd point you to footnote 22 of the court's opinion, where it specifically talked about why the numbers this court articulated in Beavis 1 were not accurate as compared to the evidence in the record, and pointed to the evidence, which is the state's own evidence, as well as ours, that is what's actually the maximum for a semi-automatic firearm. So I think you have to look at this opinion and appreciate. I mean, I appreciate the court didn't lay it out in the way that some might appreciate a court did, but you have findings that are coming along as the court is articulating legal principles and working to understand Beavis and what this court was looking at. That's where the court makes findings about what it is that differentiates an automatic weapon from a semi-automatic weapon, and made findings about how the actual reason, once the court heard all manner of evidence from military experts who talked about why the military cares about having automatic fire, that it's not just about rate of fire, and that what differentiates a military grade weapon in automatic functionality capacity is it's that its machine gun would not necessarily be banned because of the rapidity with which they deliver rounds downrange, but because the operator cannot control the weapon when fully automatic in a way that ensures that shots are reasonably aimed. That's a determination the court made after considering evidence about how what really matters in the military capacity, you don't mind that you sacrifice some accuracy with an increase.
Let me ask you
Okay, what's the next problem?
Solve for x, where x equals better grades and more confidence.
general question about standard of review, which we've been into for 3 other district judges in Illinois. Suppose we have 2 district judges in Illinois find in your favor on questions like this, and 2 district judges in Illinois make factual findings in the state's favor on questions like this. Is the law constitutional, unconstitutional, or constitutional only in part?
Look, the ultimate question of whether the facts satisfy the legal standard, we agree that ultimate question is to know.
Look, listen to my question. Counsel.
Sure.
Suppose the district court makes different findings of fact. We have to determine the legal significance of findings of fact. But suppose other district judges make different findings. What then happens?
First, you'd examine to determine whether the findings are clearly erroneous.
Have been found the other way, but are not reversible as clearly erroneous. You just have to take that as given.
Sure.
That's what
de novo determination about whether the evidence satisfies the standard. Now, in every case.
Why? I mean, it now sounds like you're agreeing with the state that these are legislative facts about which we have to make a de novo determination.
No.
But that's
on. If I all of a sudden scream and you guys hear shots in the background, I lose connection. I'm shooting my router or my modem. Let me see whether I can get this freaking screen share back up. See whether I can get this.
My question is, what do we do then?
And my answer is you answer the ultimate de novo question looking at
Jesus Christ. Let me try to let this thing catch up again. Because what Murphy's saying right here is damn important. And the way Easterbrook is damn treating her right now. Damn, my wife sent me a picture of a gun she's working on right now. And I seriously believe Easterbrook's going to rule against us just because he wants to. He's trying to find the loopholes to rule against us, not trying to find the facts of the case, weigh them, and then make an honest decision.
the fact that Bruin did say party presentation matters. And inherent in the notion that party presentation matters is that, whether you consider them legislative facts or adjudicative facts, and I think here we have a combination of both, and you may get a different record in different cases. This court had a case recently where it said, we're not going to answer this question or really revisit any of this because you made no factual record whatsoever. I don't think that means that, we lose. We made a factual record, and now you examine the factual record that we made. And if somebody comes along and makes a different factual record, that can happen in all sorts of constitutional contexts, not just in the Second Amendment context. And it might be a reason that courts think again, but it doesn't mean that you should ignore the record and the findings and all of the things we put on here below that did lead the district court to reach the conclusions it did. And I'd love to talk about, you just heard a lot from the state about the evidence, put on all sorts of evidence. And I want to be clear. We put in a bunch of evidence, not just about AR-15s. We tried this only on AR-15s.
Did the district court, though, the district court's opinion?
This is more than a bundle.
God,
It's more than a
is it just me or does everybody know? All right, are we back here? Is my yo-yo ass connection back? Back here? My yo-yo ass connection back? All right. Well, I thought we were all. Yeah, I thought we were all right, but I'm not hearing audio from the screen share. So hold on. Let me stop this and restart it. Yeah, I thought we were all right, but this is not hearing audio from the screen share. So hold on. Been ridiculous, and it's getting more ridiculous. This is catching something in the background. Either way, I'm going to try to play this some more. I got to leave out of here in about 45 minutes to get kiddos, and then I'm going to probably crank one back up just to look at the documents that the state is using in this case, at least a couple of them, and just kind of run through those, and we can look at the insanity and make fun of anti-gun idiots. One of the guys, the urgulitis, who sounds like a wild ass STD, who is a witness for the state, and I think I forgot to put it in the description, actually has his own website called gunlearn.com for all of your anti-gun needs. And he writes for a lot of these gun control cases for the gun control side. It's not like he's out defending firearms ownership. And guess what? He's an ex-ATF agent. Makes sense, doesn't it? And who knows, we might buzz through and take a look at his website after a while too.
Features that you're talking about don't vary across all of the
When the court was talking about the features, it talked about the features.
Holy, this is killing
of the
me.
record of the opinion where the court is talking about how it sees the firearms differently. And what it explained is, from the court's perspective, after understanding all the record evidence, that really what puts something on the military side of the line is automatic fire. And that automatic fire is different because it serves a suppression need, and that's why, and that the military has. The military may need to pin troops in place, keep people from advancing as you're trying to enter a structure to clear it, where you don't know who your target is, and you don't care if you're firing as accurately, you just want to fire quickly. That's like the opposite of what Illinois is coming at here, because singling out features here because they make firearms more accurate. They make it easier for someone to stay on target. So it's singling out the very thing that drives an even bigger wedge between an automatic firearm that is military grade and a semi-automatic only firearm that I don't think there's any dispute is not something that has ever been a service issue combat rifle in our military or any other military in the world. And what the district court said is, once the court looked at things like rate of fire and control, that's the big differentiator, and that in the self-defense context, you just don't have that same need for suppression fire that you might in the military context, because as this whole case is about showing, people want firearms in the self-defense context that are more accurate. You don't want to miss your target. You don't want to accidentally hit the people of the party. You don't want penetration. So that I court understood. Look, there's a bunch.
All right, that is about to drive me completely up a wall. So we're just going to sit around and shoot the breeze for the rest of this one. And before I start back, when I start up the next stream, I'll reset all my stuff and see whether I get this connection issue worked out. Because it's really getting too annoying. Tactical Muffin Top, what is up, my brother, man? Good to see you. It has been too long since I've seen a lot of you guys. Just checking a message from somebody. Yeah, my wife sent me a picture of a piece of brass from a gun. It's a Derringer, and it looked like the firing pin almost went completely through the primer. I mean, almost completely through it. So, yeah. Apparently the dude dropped it. Not what you want to see when you drop your gun is a firing pin smacking a primer so hard it pretty much impales the primer. Yeah, I changed some of it, man. I'm still trying to get my work area back here sorted out. So most of the plasma cuts are down. Bet it was a Davis. Could have been. She didn't tell me a make on it yet. Bond Arms, Davis. Man, I don't trust any of these Derringers. I really and truly don't. I definitely wouldn't be carrying one like pocket carry like I've seen some guys doing. No, that ain't happening. That's a no bueno from me. Let me see. I tell you what, since I stopped that other crap, okay, she said, yeah, it did go off, but no one was hurt. I bet you that dude was puckered. Seriously puckered. And I don't mean his face. Let's see. Where was... Oh, I did have that other one in a file. Colonel James Tucker, who was another guy who gave a bunch of testimony or wrote a bunch of stuff for the anti-gun crowd. That was absolutely insane. Let's see. That's STD, man. That's urgulitis. Oh, hold on. I think I say. I think because this hit this more than likely when I get back. This Lucy Allen report that the state keeps referring to. I'm really interested if my connection will. No, Sam. I'm in the same place with apparently the same shitty internet that doesn't want to do anything. No, you just see all my stuff. A lot of plasma cuts that I had on the walls and stuff. Everything's taken down. I've got to hang pegboards and everything back there for tools. And then you just see a bunch of my junk sitting back there right now, just for something to have in the background, basically. Man, this thing is just so freaking crazy right now. And I don't know. How in the world? Let me see something. I don't know why in hell this is acting as crazy as it is right now, besides just retarded stuff. How do I want to try to do this without crashing my damn internet any further? Let's see. Let's see if we can do it this way. I'll just try to share a window. And I'll see how this shows up. So this is the Lucy Allen report, the report the state keeps referring to. And we're just going to buzz through some stuff because I don't have too long, but we'll get back into this. So let's see, number of rounds fired by individuals in self-defense, analysis of NRA armed citizen database, which is nowhere by any means a complete database. Analysis of news reports on self-defense with a firearm, analysis of shooting incidents, crime data from Portland, Oregon police. Percentage of incidents with rifles used for self-defense according to the Heritage Defense Gun Use Database. So, off the rip, I would say her use of freaking Portland stuff is gonna skew results, to say the least. And then she looked at mass shootings, use of assault weapons in public shootings, large capacity magazines, casualties, number of rounds fired, percentage of mass shooters, guns legally obtained. If she uses the gun violence archive for this, I'm going to probably scream. Let's see. All right, so she's of course been asked by the Illinois Attorney General's office to do this. She talks about the ban here. I want to get down into some of her criteria. I really and truly want to see her resources on a lot of this that she used. And who knows whether she lays out an honest methodology. I doubt whether she does. And again, they started out with the uses inside or for Illinois. And it looks like she's going national with some of her data. Hold on, let me look at something. Let me pull back up because I want to read something over again that I just kind of skimmed through. Senior Managing Director at NERNA Economic Consulting. Practice and share. Product liability and mass torts practice. So you can bet she knows how to manipulate data. And again, this is a really raw look at this, guys, because I haven't read through it yet. So she's been with Nura for 25 years, been engaged as an economic consultant or expert witness, numerous projects involving economics and statistics, qualified expert and testified in court in various economic statistical issues relating to the flow of guns into the criminal market, testified at federal state courts before New York City Council, Public Safety Committee, American Association of Judicial Arbitration Median Services. All right. All right, this is getting into your qualifications. Summary of findings. Regarding the number of rounds fired with individual self-defense, analyzed 1,000 real-life incidents of self-defense and found it extremely rare for a person. Of course it is. I mean, it's rare based on the population of the United States with what, 300, say round at 350 million people in the United States. Of course it's rare. But it does in fact happen. Performed an analysis of 736 incidents in the NRA Armed Citizen Database, as well as my own systematic analysis of 200 Factivia news stories from a random sample approximating 4,800 news stories. So she went with a random sampling of 4,800 news stories. And I think her random sampling is a bit dubious. Defense with a firearm. Found only 2 incidents where more than 10 rounds were used. And one issue right off the bat with something like this is civilian firearms. Our training is always to make sure we know where every single round goes. We're taught there's a lawyer attached to every single round. So when you look at a civilian use of a firearm versus, say, the police use of a firearm, civilians tend to be way more conservative and deliberate about the shots that they fire. Now, again, she's using this huge data set of civilian uses or defensive gun uses. That's going to greatly skew the numbers to the lower end because in the vast majority of cases, there aren't shots fired. If you wanted to get a better data set, you should only analyze defensive gun uses where there are shots fired. So analyze police data, almost 4,000 shooting incidents in Portland, and found no incidents of self-defense with a firearm where the defender fired more than 10 rounds. Now, hold on, because that's something different, or something's worded screwy there. In addition, I analyzed data on almost 4,000 shooting incidents in Portland. Now, when she's talking about shooting incidents there, is she talking about all shooting incidents and not just self-defense? Because that 4,000 shooting incidents, where if you're basically putting in criminals with it, Again, that's going to be something that's going to seriously skew numbers. So regarding outcomes when assault weapons, large capacity magazines, and public shootings, this really shouldn't freaking matter when it comes to our rights anyway. Analyzed almost 200 mass shootings from different sources between 82 and 2002. I wonder if she threw out the lower numbers where it didn't even make a mass shooting because a private citizen killed the assailant before they could get it to the level of a mass shooting. And I wonder if she counted some of these incidents, because I believe, like in Parkland, the shooter did use 10-round mags, if I'm remembering right. And when you're talking about firing 10 rounds when using a assault weapon or high capacity magazine, the majority of these shootings aren't someone using an assault rifle. Why are you throwing those two in the same category? Unless you're just, again, trying to skew numbers. Because the majority of mass shootings were handguns. If you go by the strict definition of a mass shooting, the majority of mass shootings are handguns. And all gang related, but let's just, let's forget about that. So basically, if you wanted to get a true breakdown on some of this, you would have to separate out or separate all these out into categories. So rifles or all long guns, and then handguns, and then separate out whichever one was actually using a so-called high capacity magazine, if you wanted to be absolutely honest about it. Ribbit, what's up, my brother? How's it going? Opinions. So plaintiffs claim that large capacity magazines and assault weapons covered by the Protected Illinois Communities Act are commonly used for lawful purposes, including self-defense. I don't really think you'd have to go far to prove that claim, because there are, I don't know, hundreds of thousands of all these in Illinois, and there are very few crimes committed with them. She kind of throws out her game right here. The number of rounds commonly needed by individuals to defend themselves cannot practically or ethically determined with controlled scientific experiments, as there is no source that systematically tracks and maintains data on the number of rounds fired by individuals in self-defense. So she's admitting right there this is all her opinion, which kind of gets her out of the fact that they could call her on skewing the data. Calling her on her estimates, you could definitely come up with an entirely different conclusion than hers, of course. Says she had the NRA Institute for Legislative Action, as well as my own news reports. And who knows, more in these days, we might have to go look at the NRA's database just for shits and giggles. So let's see. Yeah, who knows? We might bounce over there this afternoon if we hang out too much longer. In light of the positions taken by the entity compiling data, I would expect that any selection bias would be in favor of stories that put guns in the self-defense best possible light, might highlight the apparent need of guns and multiple rounds self-defense. Again, you're still dealing with the civilian use of the firearms, and we tend to be a whole lot more deliberate about the shots. We don't have qualified immunity like the police do, where you watch them mag dump, load another mag, and then mag dump again. If we do that, even if we hit the suspect and probably nothing else, we're probably going to go to jail for endangering the public. Not so much with police, and they know that. Okay, so according to the analysis incidents NRA Armed Citizen Database, it is extremely rare for a person when using a firearm in self-defense to fire more than 10 rounds. Out of 736 incidents, there were 2 incidents, 0.3%, in which the defender was reported to have fired more than 10 bullets. So in other words, a couple of them fired 10, some of them fired 8, some of them fired 6. They bring that all the way, and they average in the number of people who don't even fire them to bring that number down to an estimate of 2.2. See, this is the biggest driver of where their numbers or where that 2.2 comes down to. So in 18% of the incidents, the defender did not fire any shots. If you average that in, you're going to drive down that average immensely. So if we're looking at how many shots are fired in a self-defense instance, you really, if you're going to be intellectually honest about this, would only use incidents in which shots are actually fired. It would be like averaging in all the police interactions with the public and saying there were 4 billion police interactions with the public and they only fired 1 shot per, defensive use. And that's what they're doing right here. All right, in 80% of the instances, the defender fired 1 to 5 shots. 2% of the instances, defender fired 6 to 10. All right, and then it's 0.3% fired more than 10 shots. So this is where they play loose with, or they play fast with this data. They're not necessarily playing loose with it. But they don't expect you to catch on to this little bit of data right here. Again, they're factoring in and they're taking instances of no shots fired to drive down the total average. And then they never really give you the breakdown. because they're using such a small data set. But it's science. We have to follow the science. Yeah, anybody who still believes that needs to go into their kitchen, find the biggest frying pan they can find, and beat themselves dead in the face with it until they not sense it in themselves or they pass out. And if they don't have any sense when they pass out, they need to wake back up and then beat themselves in the face with that frying pan again. Because we have definitely seen science, the science, as they put it, can definitely be skewed. And it just depends on who. This is the biggest thing about a lot of this. It depends on who's plugging in the data. Just say it about equations or say it about freaking computers. Garbage in, garbage out. They're putting a whole lot of garbage in and they're getting a whole lot of garbage out. Instance NRA Armed Citizens Database. All right. Gives instances many citizens able to defend themselves without firing any shots. According to one of the 134 incidents, man entered a Shell station in New Orleans, LA, attempted to rob the cashier by claiming he was carrying a gun. The cashier responded by retrieving a gun and leveling at the thief, prompting the criminal to flee. That kind of proves our point about being able to defend yourself and criminals liking unarmed victims. Hold on, what'd you put in? It might be something I'm gonna have to pull up later. Because I don't have long before I got to get out of here and bail and get some kiddos. Matter of fact, let me do. Let's see. There were 20 incidents that occurred in Illinois, so they're taking even a smaller bite of the subset there. 20 incidents that occurred in Illinois. In those incidents, the defender fired 1.2 shots average. Of the 20 incidents, there were no incidents where the defender reported having to fire more than 10 shots. 19, the defender fired 5 shots, and 1 where the defender did not fire any shots. I would pretty much guarantee you if we got into the data in Illinois and really dug down deep into it, you would find a hell of a lot more shots fired in self-defense. People may not want to get into because it is one gang member defending themselves against another gang member, meaning they weren't the aggressor in that incident. Someone started shooting at them and they started shooting back. It sucks but it is what it is. Everybody has the right to self-defense. I don't care whether it's whoever out on the street. If you are not the aggressor and someone shoots at you and you start firing rounds back, that's still self-defense. And the NRA does not pick up all the incidents of self-defense. And the news damn sure doesn't report on all instances of self-defense. All right. The search was designed to bring in instances of the NRA, armed citizen. So these are the search terms they use going through their news stories. Gun, shot, shoot, firearm, shooting or armed, plus words broke in. So the search criteria matched 90% of NRA self-defense with a firearm in the home. And the analysis, 10% of stories that are not returned by the search show the typical number of shots fired in these incidents was no different than in other instances. Evidence for the state's case. Do you not think that they're going to work hard to skew the data? Says it returned 35,000 stories for the period of January of 2011 to May 2017. Using a random number generator, a random sample of 200 stories was selected for each calendar year. 1,400 stories in total. 1,400 stories were reviewed by me and my team to identify those stories were relevant to the analysis. Incidents of self-defense with a firearm near the home, or in or near the home. I'm sorry, I'm leaving stuff out. Methodology yielded a random selection of 200 stories described incidents of self-defense. So their methodology out of, what did we say, 1,400 stories, whittled it down. Their methodology whittled it down to 200 stories. Thus, out of over 70 million stories aggregated from January 2011 to 17, approximately 4,800 news stories were on incidents of self-defense with a firearm in the home. And again, most of these incidents never get reported on. I mean, if you're paying attention, you'll see plenty more stories where homeowners are using firearms in self-defense, but you just don't see them reported on. All right, I'll tell you what, though, guys, it's already 3:53. I got to leave the house in just a minute. So let me kill this one here. Again, if anybody wants to look through this, the links for court listener are down. This report is on the second page. And you can look through these too. And this is just a raw look at it. I haven't been through these numbers yet and haven't looked at the information yet. That's the reason I'm kind of breezing through. You don't see stuff highlighted and I don't have notes on it. But anyway, let me let you guys go. Hopefully we'll catch you guys here in a little bit. If I do crank another one up, let me see kiddos and get them back here and see what we got going on. Anyway, I love you, perps. It's good to see you guys again. And I will catch you on the flip. And as usual, keep that thing on you at all times. Later.